Hi, folks. My name is Greg McLaughlin. I'm an immigration lawyer based in Seattle, Washington, and my law practice focuses on issues relating to the USCIS Form I-864 Affidavit of Support. And I heard the great news this morning that the Biden administration has announced the United with Ukraine parole program that's going to allow 100,000 new Ukrainian, not technically refugees under US immigration law, but Ukrainian refugees into the United States under what's called the Humanitarian Parole Authority. One of the components of this program is going to require sponsorship from a US individual or entity. And I wanted to get out ahead of this and mention in advance that I believe with great deal of certainty that this is not going to involve the binding financial support contract called the USCIS Form I-864 Affidavit of Support. And that's probably really important for folks to know as we learn more about this program, because the Form I-864 Affidavit of Support imposes some really serious long-term financial obligations on a sponsor that just aren't going to apply to the Unite with Ukraine program. So let me just give a real quick thumbnail of the I-864 Affidavit of Support and explain why that's not going to apply to Unite with Ukraine. So the Form I-864 is used primarily in family-sponsored immigration cases, where you have a spouse, parent, child, or sibling who's petitioning for another family member to come to the United States. As part of that process, there is a statutorily required affidavit that has to be executed by the US family member. That's the Form I-864. That contract requires the US family member to show that they have the ability to maintain the sponsored immigrant at 125% of the poverty guideline. That's about $1,400 per month. This was created by Congress in 1996 after determining that the affidavits that were then used in family-sponsored immigration cases were unenforceable. The old affidavits are called the I-134 Affidavit of Support, and courts had previously held that those old affidavits were unenforceable. Remember that. So in 1996, as part of revamping US welfare law and immigration law, Congress placed a new financial burden on family-based sponsors, and that's where the Form I-864 affidavit comes from. So now, since 1996, virtually all family-sponsored immigration cases have required this binding affidavit. What we have with Unite with Ukraine falls under a totally different part of US immigration law. And that's the portion of law that allows the government to exercise a discretionary authority to do something called humanitarian parole. Parole is kind of a weird thing under US immigration law because it's not a visa and it doesn't confer a lawful immigration status in the sense that residency is a status. Basically, it allows somebody to enter or remain in the United States for a limited period of time, and there can be work authorization status associated with that, but it's not a path to citizenship, and it's not the same thing as US residency. The example that almost everybody will be familiar with is something called the DACA program, Deferred Action for Childhood Arrivals, which was announced under the Obama administration. This allowed certain young folks who had come to the United States under age 16 to remain in the United States and have a lawful immigration, and have work authorization status for a while. Another example that folks might not be real familiar with is parole in place, which is for immediate members of US service members. So if you have no lawful status, you're married to somebody who's in the Army, that provides a parole authority so you can start normalizing your immigration status. That same statutory authority is being used for the Unite with Ukraine program. That is important because an application for parole is not technically an application to be admitted to the United States. Because remember, you're not applying for residency or another status of that nature. You're just getting paroled temporarily into the United States. For that reason, statutory grounds of inadmissibility don't apply. One of those grounds, and this is where the Form I-864 comes from, is called public charge inadmissibility. That is the long-standing law since the late 1800s in the United States that requires intending immigrants to show that they're not likely to become a financial burden on the American public. That's why Congress in 1996 upped the ante in family-sponsored immigration cases. But that public charge ground just does not apply in parole cases, and so it doesn't apply to Unite with Ukraine. I'm just going to answer a quick question here. So the question is whether the Unite with Ukraine applications are going to be different from the Afghan apps. Right. So we also, US, exercise parole authority for Afghani refugees. And this should be similar to that program. So it's the same statutory authority. So again, public charge inadmissibility, inapplicable to Unite with Ukraine. And that's important because the affidavit of support that is binding is specifically tied to a component of public charge inadmissibility under 8 U.S.C. 1182 C4. And there's kind of a narrow, well, it's actually a large part of U.S. immigration that it applies to, but it's a specific part. Here's an example. Fiancé visas. When you go through the consular part of a fiancé visa process, you are required to submit an affidavit of support. But it's not the binding affidavit of support, because the statutory component that applies to binding affidavit of support doesn't apply to temporary visas. And the K-1 fiancé visa is a temporary visa, albeit one that you can later use to convert to US residency. But under the Foreign Affairs Manual, there's a specific component that says it's a mistake for the consular officer to require the binding affidavit of support because that's not used in temporary visa applications. So for the same reason, it would be inappropriate to require the binding affidavit of support for Unite with Ukraine. What is more likely to be used, and again, we just heard about this program this morning, so we're getting out ahead of it a little bit here, but what is probably going to be used, if anything, in this regard, is that old I-134 affidavit of support that existed prior to 1996. That old form, I-134, is still used, again, like in that fiancé context. So where the binding affidavit of support can't be used, the State Department relies on that old I-134 form. And what's interestingly different about the I-134 is that it basically has a place on it where the sponsor can list the types of support that they're going to provide. On the binding affidavit, it just tells you, look, if you sign this, you are responsible for maintaining the sponsored immigrant at 125% of the federal poverty guideline. For the I-134 form, you can describe the types of in-kind benefits that you're going to provide. So for example, you might say, I'm going to provide clothing, shelter, etc. for this intending immigrant. Same sort of thing might be used in the context of Unite with Ukraine, where the sponsor is providing in-kind benefits such as food and shelter, access to employment training, etc. So the bottom line for now is that folks should not, it appears, be scared away from participating in this program, which is of tremendous use to the Ukrainian population, should not be scared away from it by thinking that, uh-oh, this involves that scary affidavit of support, the I-864. That, we don't know for sure, but that almost certainly is not going to be used in this program. What's going to be used instead is the non-binding I-134 form. So that issue, the financial sponsorship issue, should not scare businesses or individuals away from participating in this program. I hope that's helpful. If you have questions, comments, feel free to jump into the comment section and I'll answer them to the best I can. And when we get more information about the program and the financial sponsorship specifically, I'll try to do a follow-up video.